We're on the record.
All right, this is the special meeting of the Sunshine Ordinance Task Force Rules Committee, called to order at 4:05 p.m. Mr. Clerk, would you please call the roll?
This is the meeting of the Rules Committee of the Sunshine Ordinance Task Force for September 26, 2017. On the call of the roll, Member Highland has indicated he is unable to attend, and I believe that Member Moss is has been appointed in his place for today's meeting.
Yes.
So, Member Moss?
Here.
Moss present. Member Fisher? Member Fisher has informed me she'll be here shortly.
Okay.
Chair Hensey?
Present.
Hensey present. We have a quorum. There are no agenda changes that I know of.
Okay.
Next on the agenda, item number 2, adoption of the minutes for the October 25th, 2016 Rules Committee meeting.
The chair would like to entertain a motion.
With the caution that I was not at the prior Rules Committee meeting, so I can't attest to the veracity of the minutes, but I will make a motion to approve them.
Thank you, Member Moss. And I'll second it myself since there are only two of us.
Comment. Public comment.
Oh, public comment on the motion to approve the minutes? Oh, and I'll note that Member Fisher walked in at, I don't know the time. 4:05. All right, cool. We're just about to take a vote.
This is the motion to approve the minutes from October 25th, 2016.
Mr. Clerk, would you please call the roll?
On that motion, Member Moss?
Aye.
Moss, aye. Member Fisher? Aye. Fisher, aye. Chair Hensey?
Aye.
Hensey, aye. The motion passes. Next on the agenda, item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda.
You get 3 minutes.
Hello. So, this is my first time here. What is this in relation to?
You can speak on anything not on the agenda today that is within the committee's jurisdiction.
Perhaps a moonwalk, a song.
Do you have any concerns Sunshine concerns?
Well, I guess when I'm concerned,
Through the chair. What brought you here today?
well, what brought me here is I usually dance in Union Square in different areas, and I've been being harassed and told that I can't perform at certain places for reasons that I don't think are valid. And I was looking for an entertainment department or an event department or any place where I could get a permit or permission from City Hall to perform at a certain place. And
Through the chair. Thank you. We don't have any jurisdiction over this. Victor, you might know. It's not
probably a good place to start would be the Entertainment Commission.
Is it entertainment? Because I know about 4 years ago, my girlfriend got a busking. Who does the busking permits?
I'm not aware.
Google busking. Busking. Go on the Sanford SF.gov website and look up busking, because I know that when my girlfriend did Christmas songs and had amplified music, she had to get a busking permit.
where's the Entertainment Commission?
Entertainment Commission is more for alcohol and entertainment in specific bars, like Type 48
You
license,
might want to
42.
check with Public Works because they have control over public streets.
Yeah, I know. I actually did this 4 years ago. That's why I jumped in over the chair here to tell you. Now, you're not. Are you using amplified music?
I am.
Yeah, that's the issue.
A little research needs to be done.
Yeah, this is so out of our jurisdiction, but we're here.
But what if you're not using any music? What if you're just standing
you
We
there?
really wouldn't be able to give you any specific information as we're not the party involved. We're just giving you suggestions at this time.
Okay.
We're just happy to see you.
Yeah, I'm happy to see you guys too.
Take a selfie.
This is so funny. Oh my
Back
gosh.
here, let's get a selfie.
I'm innocent. I'd like the record to show that I'm innocent.
Yeah, it's not our jurisdiction.
Unfortunately, this is not the meeting to clear your name, so to speak. But
Through the
yeah.
Through the chair, one more comment. I'll tell you what, if you don't get the information you need and you feel like people are holding back documents, then by all means, come back to us. We'll hear what you have to say.
Actually, you can call 311
Why you
and
making me laugh?
Good idea, yeah.
This is not funny.
You can call 311, ask them for where to get a permit for what you're interested in doing. Because they are the city's information line.
I've got it. It's called the Street Performer Program.
Is that the,
Yeah.
that's the port, right?
There actually is a street performance permit. Of course, they're not accepting new applications at this time.
What is that through?
This one is through the port, which I'm going to assume would put you up at Fisherman's Wharf and the Embarcadero. I don't think that covers like Union Square or any other areas. But I would look up, I just Googled San Francisco, and I put busking permit or street performer.
So the ground is public property, right? Like the street is public property or public?
Like I said, we don't have that kind of jurisdiction or information.
Okay.
That's a public works issue, since
Public
they have control
works.
over the public streets.
Okay.
No. It's just not it's something we can handle.
Yeah,
Okay.
I mean, try BART, because that's out of our jurisdiction.
Oh, man.
So we can talk about that here.
What is your jurisdiction?
I'll let you answer this.
So our jurisdiction is access to public records, so documents that you might need in connection to this. If you don't get them, you can by all means come back to us. We also handle open meetings. So if you feel that your rights were violated at a meeting that you tried to attend in connection to this, then you can go ahead and come back to us. But at this point, your issues are not in our jurisdiction.
Okay. Thank you so much. And
For what it's worth, I remember this, is that BART, you do require a permit, but they are free, which is nice. Because they,
how do I get one, though?
You
go,
need to contact them directly. We
Oh, the
really
BART.
don't have this kind of
You
information.
get a
for
free
you.
permit for BART. That's
You need
cool.
to contact them directly. We just can't give you any solid information because we are not the holder of that information.
All right. And let the record show that I am innocent.
hey, thank you. This is the most
Is there
interesting
additional
thing
public
we've ever
comment?
had.
Okay, public comment. The San Francisco Arts Commission staff lie constantly, and they hide behind attorney-client privilege. I had two successive Board of Permits and Appeals hearings. Ann Trickey of the Street Artist Program claimed that I called her office constantly, yet she had only one phone call from me in 5 years. She claimed that I use various fake and assumed names. I don't. I have one, that I'm abusive to staff and commissioners. She claimed that I was abusive under public comment at meetings, and she didn't need to supply evidence. That none of this is true. At various Sunshine hearings, we've seen Arts Commission staff members come without files, without paperwork, with one staff member lying and another to support the first one's claim. When questioned, Kay Patterson claims she doesn't remember if she sent documents. To me, the Arts Commission is a house of cards with no foundation. Not 15 minutes ago, I saw Tom DeCaney in the Mint Cafe in the basement. I asked him if he would be coming to the hearing later today, and he just snickered and walked away. So there's my public comment.
No other public in the room.
There being no further public comment, this matter is concluded. Moving on to the next item, item number 4, file number 17103, review and possible amendment to the Sunshine Ordinance Task Force bylaws and complaint procedures. There are a list of items on the agenda for our discussion at this time.
So should we just go ahead and take each of these in turn? We can start with the rule of reason, though, since we have the author here.
Sure.
Oh, how convenient.
That's part of the reason I came today, and then
Happy to see you.
And then Member Highland couldn't join. I was going to be a guest to present, but then Member Highland
Here you
asked
are.
me to sit in. So just for background, the rule of reason has come up, I think in part because of a case that Councilmember Peskin's office had, in which, just for background, that a member of the public, Mr. Petrellis, had asked for, I believe, something like all emails they had during a given time period, and rather than do any kind of search for the records, they just came back and said rule of reason. And we wanted to see if whether our policy could be written in such a way to account for the rule of reason, or to have a series of requirements or questions that would need to be established for the rule of reason. And the rule of reason, sort of as I understand it, is, if somebody comes and asks for everything, every document that you've possibly ever had, whether there's a way for an office to say, there's just no way for us to comply with this if we don't dedicate our staff 24 hours a day to complying with this thing for the next 5 years or something like that. Essentially, the idea being that there needs to be a level where a thing becomes unreasonable. And so Chair Wolf had asked me to sit down and draft up some procedures that might make sense. And so I did one draft, and then he asked me to write another draft that went a little bit further. And so I went a little bit further on the draft, and that's the one that we're looking at today, with the idea that I include more than I would necessarily have sought myself, and then we can just sort of discuss and pare it down to what makes sense. But you'll see that it's quite long, and it starts on page 19 of our packet.
Do you want a paper copy? You have plenty.
Yes, if you have them, thank you. They've already been printed.
Yeah, so it's about 2 pages of documents. So 19 and 20 is where this comes together. So I'm not exactly sure how we should go about this, but we can, I guess, start at the beginning. And the first thing that I had written was that if a respondent is going to invoke the rule of reason, they must provide something by the head of the department authorizing this as the justification. It can't just be a staff member pulling it out of nowhere. And that if the head of the department is not named in the complaint, then they need to volunteer to be added to the complaint. And
To clarify that means that if a department is invoking the rule of reason, a department head needs to be on the complaint somewhere?
Yes.
Okay.
So if somebody files a complaint against a staffer, like let's say, for the purposes of this, I'm just going to use Victor as an example, if that's okay with you. So somebody files a request with Victor, and then files a complaint against Victor. Oftentimes, Victor would have to come and testify before the committee. If Victor wanted to say rule of reason, Victor would have to say that, well, it's not just me saying rule of reason, it's Chair Wolf who's also saying rule of reason, and Chair Wolf is going to join the complaint so that he is also culpable for this argument. At least that was my thought about why to include that.
That makes sense now that you explained it in that way. That sort of makes sense. Yeah.
And we don't have to accept all these. I just want to explain why.
I'm just trying to understand it. Yeah.
So I'm still trying to read
So
this.
page 19.
Yeah, number.
And it says H miscellaneous. Everything underlined is what I added.
I'm on 20. Page 19.
Yeah.
Sorry.
Line 10.
All right, thank you. Line 10.
Sorry, yeah, line 10.
Okay.
And then line 13, which is part of the same thing, is that having a letter from the city attorney's office that the city attorney's office also agreed that the rule of reason was appropriate here.
Are you saying and or in addition to? Because are you saying you have to have both
It's
these?
up to us to decide that, if we think both of them need to be, or...
I mean, when you wrote it, did you have an intention?
I just assumed that a city attorney would write a separate letter concurring with the department. To me, if a letter came and it was signed by all of them, that would also fulfill the same need.
Yeah, I could go with.
With the city attorney, I'm just playing the other side.
That's fine, that's
Yeah.
fine. I
They
know
may
it-
not want to
no,
get
that's
involved with determining what a department considers to be burdensome. we would have to get the city attorney's opinion on that to see if they feel that they have the ability to sign off on rule of reason or not.
Okay, well, let me ask you a question then, because I think the reason I was thinking about that is that if I'm not mistaken, under the Sunshine Ordinance, the city attorney is the official custodian of records for the city of San Francisco. Am I misremembering that?
I don't. Every department has their own custodian.
Right.
Yeah.
I think
The city attorney advises departments and provides advice regarding Sunshine, but they are not the actual holder of the record.
Yeah, I'm gonna just make sure I'm looking at the right thing.
This is one of these things that looks like really good in theory, but in execution, the city attorney may say, "We're not doing this for every department." I mean,
Yeah.
if,
And
for
it's the
example, the
cost
Arts
also.
Commission, comes along and says, "Hey, we're doing rule of reason," and then the police department, "Hey, rule of reason," the city attorney is going to go, "We don't do this."
Yeah.
So that's what I'm worried
Even though
about.
many of them do get advice before trying to invoke rule of reason, just because it's such a high bar, I don't know if we want them to sign off on that or not.
I'd almost make that as like, what is it in legalese, where you could do a and or. I mean, it doesn't have to have both, but maybe it has to have number one, but it doesn't have to have number two. Or
Well, just
Line
to
13.
clarify, what I meant earlier is that under the ordinance, the supervisor of records is the city attorney, not the custodian, but the supervisor of records under the ordinance is the city attorney.
They have
That's why.
a different function in a way, in that they function outside of the task force, where you can petition the supervisor of records to make a determination of whether or not a document is public or not. I'm not sure if their duties would expand to this.
Well, I think that's what I mean, though, is that if somebody went to the city attorney and said, "I want you to declare that this is maybe this is totally off base, but I mean, if I filed a public records request and it was rejected, my next thing, I could go straight to the Sunshine Task Force, but theoretically I can go to the city attorney's office and say I want a declaration as a supervisor of records, at which point the city attorney would have to say, well, you've asked me to make a ruling on a far too large body of records for me to rule on, and therefore I am also making the determination that this is unreasonable.
Something to consider.
Yeah.
To see
So,
if
maybe it's all right. I'm fine with cutting it. But
No, we can leave it there and have further discussion. I just was throwing in the other side of the story.
No, I agree. I don't necessarily know. The city attorney would ultimately have to defend this in court, right? So they would have to make the rule of reason argument. But I'm fine cutting it if folks don't like it.
Yeah, it's not that I don't think it's that we don't like it or
Yeah.
think that it'd be a great idea. I just think that buy-in is going to be a little challenging.
Okay. All right. I'll make a note. Okay. So the next thing starts going into the California Public Records Act. So it says that a respondent who invokes the rule of reason as justification for delaying a response or denying access to public records requests should demonstrate compliance with Section 6253.1 of the California Public Records Act. And this section requires a public agency, quote, in order to assist the member of the public to make a focused and effective request that reasonably describes an identifiable record or records, and then asks for sort of three things. And the first is that they need to assist the member of the public to identify the records and information that are responsive to the request or to the purpose of the request, if stated, describe the information technology and physical location, and suggestions for overcoming any practical basis for denying access to those records. And then if they've done those and the person is unable to, the requester is unable to still identify the records, then the request can be declared closed under the Public Records Act. So this section is really just saying that if you come in here and you're going to say the rule of reason, you need to show that you did the three things that the law requires. Did you prove to us that you assisted the requester to try, you at least made a good faith effort to assist the member to identify or narrow their request. You gave the respondent the location of the location of the information, and then if there was, what suggestions you made for overcoming the practical basis. So in the case of something where they've asked for all of the emails, the council should say, here's my correspondence saying that I asked the member of the public, is there a way we can narrow it down? Is there something, something? The person should show correspondence that says, listen, all of our emails are stored on our server. And then finally, maybe the person, show an email where the council member's office said, hey, listen, if you're able to say between, I'm looking for emails from this period to this period, or I'm looking at emails from this person to this person, like we can help you better narrow it. And just proof that they actually went through this rather than just going straight to rule of reason. And then they have to show that after they did those three things, the requester was still unable to narrow their request. And then if they've done all four of if they've demonstrated those four pieces of evidence to us, without doing all four of those things, we're not even going to consider the rule of reason, because those are the things that need to be fulfilled first.
That all sounds great. But if they plan to invoke the rule of reason, are we good? I'm assuming we're going to tell this to them in advance and codify this in our bylaws and all of that.
Yes, although what I would say here is that this is actually the law already. All we're saying in at least in this section of the rules, or in this section of my proposal, all we're saying is pointing out to them what the law already is, and that if they come in here, we can just ask them these things anyways and throw it out. But this is just putting it in our policy that these are the questions we're going to ask,
right.
And the person can expect to ask these questions if they're going to cite the rule of reason. So that's where I was going with that.
All right. Sounds good to me. You got anything?
No, I got nothing.
Okay. Yeah, and so then the next part just sort of says if they did not make a reasonable effort through items 1 through 3, then a rule of reason justification may not be found. And so that's kind of that. Then I'm just trying to refresh my memory on the next part. Let's see. So I guess this second part is from the Sunshine Ordinance. And I guess that under the ordinance, I'm just going to bring this up so I make sure I'm getting this right. So under 67.21C, and so under Section 70, I'm sorry to jump around here a lot, but 67.21C of the Sunshine Ordinance says, a custodian of a public record...
What page are you on?
I'm actually going just straight to the ordinance.
Oh, sorry, go to the ordinance. I remember this.
Yeah.
Okay.
A custodian of public record shall assist a requester in identifying the existence, form, and nature of any records or information maintained by, available to, or in the custody of the custodian, whether or not the contents of those records are exempt from disclosure, and shall, when requested to do so, provide in writing within 7 days following the receipt of a request a statement as to the existence, quantity, form, and nature of records relating to a particular subject or questions. It's a very long clause with enough specificity to, yeah.
We know. This is my 5.5 year here.
Partly I'm reading it just for the recording. Relating to a particular subject or questions with enough specificity to enable a requester to identify records in order to make a request under B. And then when a custodian of any public record, when not in possession of the record requested, shall assist a requester in directing it to a proper office. That part is kind of irrelevant. But the point here is that we're going to ask them questions under the Sunshine Ordinance, a requester is allowed to ask for a document in writing 7 days after the request regarding do things exist, how many exist, where do they exist, and what are they? That is required within. It's not an automatic thing. The requester has to ask for it, and they can ask for it after 7 days. And so the question here that I've added is that we'll be asking people: did the requester make this request for 7 days, and did you comply with it?
So
if the requester didn't, then we get to ignore it. But if the requester said, hey, 7 days have passed, can you tell me, do these emails exist? Or can you, give me your statement via 6721C? I'm not sure if I'm explaining it really that clearly. I'm kind of reading myself right now.
So basically, the requester has 7 days to sort of ask a follow-up question.
After 7 days, they get to ask the question.
Okay.
My understanding is we're going to ask them, did the complainant ask this question? If they didn't ask the question, nothing happens. But if they did ask it, we would have to find out if the respondent replied.
Yeah.
Oh, that makes sense.
Simplified.
Yeah. Thanks for clarifying. The point of these two things that I've put out there are we need to make sure that before they declare, they can declare the rule of reason, but first they have to have done everything the statute requires procedurally. Like, you can't just jump to it. So these are things that the Public Records Act requires, and then this is what the Sunshine Ordinance requires.
That makes sense.
Yeah.
Yeah, that makes
Yeah.
These to me don't seem like particularly burdensome requirements, or at least things to ask about in assessing our use of the rule of reason.
Yeah.
So that sounds good to me.
Okay, so then the next part.
Got any?
Oh,
Got
so-
Member Fisher?
I'm good.
All right.
So then the next part is not language I put in there. That's just what was handed to me. And so then the next part that I wrote starts on 63. Yes. So this is where it starts to get different, and I'm coming up with requirements of what I'd be curious and I would end up asking during a hearing, and I was just sort of brainstorming whether they should come to the hearing prepared with this information or not. So if they're going to call the rule of reason because a request is unduly burdensome or the volume of material is also burdensome, they should be prepared to testify and show documentation of the following things. The first is they need to be able to tell us an estimate of how much time or resources would take to fulfill the request and how they came up with that number. So the formula used to generate this estimate. So if somebody comes in here and says, or say, going back to the example of somebody's asked Victor for every email from 2017, and Victor's like, that's super burdensome. Victor would need to say, like, just to do 1 week of this would cost X amount. It would take 8 hours a day for 7 days for me to do all of a week's worth of stuff. I calculated this formula based on how much it has taken us to fulfill records in the past, or whatever. Just give us some idea of, rather than saying this is going to take too much time, say, well, this is going to take a year for us to fulfill.
Right. Self-quantifiable.
Yeah, something. It's and it's an estimate. Like, it doesn't have to be perfect.
Part of that, I was just reading through the four. In the past, when this has occurred, we've asked the departments to try to do a small portion. Let's say they want a year. We tell them, do a week and tell us actually how much time it took you to do it. So not just an estimate, because generally the departments overestimate how long it actually takes them to do the work. So I would suggest maybe proof of how long it's going to take you, not just an estimate.
Yeah,
That's just a suggestion of what previous committees have done.
Yeah, I think that's good. We need to phrase that in such a way that that it's not specific to the email example that I'm giving.
Yes, just some small portion.
Yeah.
Or actually, if it's not an email, it's kind of hard to narrow it down, but some kind of physical proof.
Okay. So number 2 was we wanted to know the amount of time and resources they have already expended on the request. So rather than coming in here and saying, well, we just got the request, decided it was too much, and we went straight to rule of reason, they would say,
they've tried.
yes. So they want to say, we can make a judgment on it, but they need to be able to, a lot of this is, they just need to be prepared with this information. They shouldn't be coming in here and we ask them this question and they say, well, we'll get back to you with it. Like, part of the purpose of putting it together is so that people are aware of what we're going to be asking. And so one of the things we're going to be asking, well, how much time did you put into this? Well, we spent a week on this, we spent a month on it, and we just realized it was too much. The third question was, and maybe this is a bit cheeky, but my question when people say, "Oh, this is going to take too much time," my question is, well, how much time would you be willing to expend on this? Like, how much time is just enough time? Like, if somebody asks for all of a year's worth of emails, and they're like, well, that's too much. Well, how many days worth of emails would be considered unburdensome? And
I would think that would be more staff time than product related.
right. So you think that? So I did say the maximum amount of time and resources. So if I said,
I think the way, the way you write it is fine. It's clear to me that time is employee time
yeah.
or staff time.
Right. So if they said, well, if we would be willing to have somebody spend a week on this full time, that would be considered not burdensome any more than that would be. So just a signal from them about how much they would be willing to commit to it. And then the fourth one is I had asked that can they show proof that they have sought greater resources with which to pursue public records requests. And it struck me that if somebody comes in here and says, we just don't have the ability to handle this is so burdensome, and then they've never actually asked for more capacity, they've never asked anyone. Now, it's not their fault if they can't be given the resources to deal with it, but certainly they can ask. And so I had suggested that maybe they need to show an email or a letter that at some point they did ask for more resources with which to handle public records requests, and they just didn't do it. I mean, they just didn't get it, rather than, well, because you could say that, well, this is really burdensome, and why is it burdensome? Well, it's because we don't have any staff at all to deal with public records requests, and so any request is going to be burdensome as opposed to.
I get you.
This one could be questionable because we can only ask for additional resources once a year.
Right. But I mean, that would be enough.
The number 3 is the one that we need to focus on, where how much time are you allocating to working on this?
My thought with that one was that if they'd asked within a year, that would be sufficient for me. That if they had asked in their annual budget for more resources, But I'm fine to cut it as well. That was just my inclination.
Like I said, I'm just pointing out the other side.
Right. I guess the question for us is, somebody says something's too burdensome, what should they be doing to build their capacity?
That.
Yeah.
Is it a regular occurrence? Should you be addressing it with additional staff? Because I believe last week the planning department indicated that they've had a large increase in requests for public records due to all the buildings popping up. And they've actually asked for additional staff to help with public records requests. But that's a long-term goal.
Yeah.
That's one department.
Right. And I wasn't specifically saying you asked for greater resources to deal with this public records request, but for public records requests in general.
I mean, I think it's a good question. Right.
Maybe we shouldn't say city budget, just ask for additional resources. Because they could ask for borrowing people from other sections and so forth.
Yeah, that seems reasonable.
I think so. That seems reasonable to me.
Yeah, I mean, we just want, when they submit a rule reason complaint, we just want them to maybe your intent behind this was maybe to indicate that, hey, maybe this is a red flag. Maybe we need, more help in our...
Is it a one-time instance or is it a pattern?
Our public records requests in general, etc. So,
Yeah.
yeah, that seems reasonable.
Okay. So we're pulling the city budget part from that.
Yeah. Member Fisher?
Nope, I'm good.
Okay, and so then the next part is, in addition to that, a respondent who invokes the rule of reason because it would require production of an unduly burdensome volume of material should provide the following testimony and documentation. And I said two things, that they should provide. Yeah, they should provide a sample of the records it could provide during a reasonable period of time. So they could give us an example of what we're talking about here, and then provide an inventory of the records or categories of records that they've identified so far that are responsive to the request. So in the example of somebody filing a request with Victor for all of his emails for the year, Victor would come in and say, here is a selection of records from one day, and that's what it looks like. And this is how, here are the 15 emails I received on that day, as well as here is the various categories of records there are there, because they should actually have an inventory of records already. Is that not?
This is, our inventory of records are pretty generic because there's so many different types of records out there. And I think it would be specific to the request.
Right.
Just saying what kind of records we might have, not saying that they exist or not exist, but maybe just say, we might have records in this type of category, but we need time to go look for it and review it. Sometimes sorting is needed because they don't separate different types of documents from each other and so forth. Or maybe it's burdensome because they need to go through each document and redact everything.
Right. And I guess that's what I was getting at, is that if they're saying it's going to take too much time to go through these 10,000 emails I have, at least they can say there are 10,000 emails here.
State why it's burdensome, and if possible, provide an inventory of what types of records may exist.
Yeah. I mean, I wrote this one as should. I didn't write this as a must.
All right, Fisher?
That's what I was. My concern is, like, how many things are we asking them? So the first 4, and then the other 2, and.
I think that the thought was when Chair Wolf spoke to me is that the rule of reason should be used very, 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 very rarely, and if you're going to use the rule of reason, you need to be able to document. It needs to be like crystal clear that there was no other option other than to go rule of reason, which this may be too far. So I'm happy to cut this if this is too much. The only things that I actually have put in here that I said that must be had are the things that are required from the law in the first section. The things that I've said on page 20, on the sort of second page of things, are things they should do to prove their case. Now, we don't have to, if they're missing any of these, that doesn't mean we have to rule against them. It's just that they know coming in that their case is going to be stronger if they can prove all of these things, because these are things we're going to be curious about.
Right, and I see that.
And, in my, first 4 years on this task force, nobody ever used the words, nobody ever invoked, unless, I don't remember, I did miss a few meetings, anybody ever saying the words rule of reason. There were times when they came back and said, this is too much, it's really burdensome, can you narrow it down? And there was a back and forth. So I think the rule of reason just kind of became, the shiny new toy that everybody felt that they could use. So now we have to kind of tighten it down a little bit, shall we say.
Had, one complaint in particular where the departments used the rule of reason quite a bit.
Oh, I know exactly who you're talking about. Yeah.
I think it's a problem with both sides. People are getting used to the public records law, and they're asking for more and more information. So it's, I think it's both sides that are pushing each other and causing this to happen more often.
Yeah. And I mean, we could have, of course, end up with situations where somebody is, in order to pursue a vendetta, might file an overburdensome request, knowingly that it's overburdensome in order to cause problems, or that is the interpretation of the recipient of it, that this is something meant to cause problems and isn't a legitimate request. But really, the motivation of a request is not our concern. It's how it's treated. The final thing here on this list, which starts on 86, line 86, this is things for the task force to consider, to help guide us when, these questions that we can ask ourselves when somebody uses rule of reason. And so the first thing is, did the respondent provide evidence and testimony that the agency engaged the requester in an attempt to focus the request? So is there emails, letters showing that they did try to work with the requester? Number 2, did the respondent provide clear and convincing evidence, including documentation, showing that complying with the request would be unreasonably burdensome? Like, they can't just say it, they need to detail why. And then finally, did the respondent provide a detailed estimate of the resources and staff time that would be required to comply with the request? And is this information contextualized by the overall resources of the staff? So I think 2 and 3 might be a little duplicative. I think the idea with 3 is that, did they tell us that this was going to, take a million years, or did they just say it was going to take too long? I guess the difference between 2 and 3 is that 2 shows why the request is brought, and 3 shows why their office is inadequate to deal with the burdensome request. And that's the extent of the procedures that I had written.
I don't see, all this seems very good to me. It's just a matter of, is there a way for us to simplify it for the common person to understand easily?
Yeah.
And for the departments.
I mean, and these are all going to, we can write, we're the rules committee. We could write 200 pages of rules. But what it's going to come down to is these are all going to be handled on a case-by-case basis. We, the adjudicators, are going to have to make decisions, and obviously it's going to fall into 3 categories. The people that are going to come in here and say, rule of reason, no time, bye. We're going to be like, yeah, no, hardly. And then there's going to be the ones that are going to rarely do it. We're going to say, all right, we need to look into it. And most of them are going to fall into the middle of, this is what I can provide in this amount of time. And we get IDRs where people want, things that take hundreds of hours. We're like, you're going to do that in an IDR. Come on.
Actually, I don't think this goes too far at all. I think this is just
What he said.
clarifying
Okay.
what we should be doing.
Yeah.
It's just a matter of how do we implement it.
Yeah, I guess so. I think that for me, when I look at it in writing it, I was thinking that this would be most useful at the committee level, where they come in and maybe they say rule of reason. They're like, well, we're not adjudicating this today, and they start going through this list and you need to answer all these things before when you come to the full task force. That this might help focus the arguments and the presentation of evidence. One thing I didn't address is the IDR element, because IDR requires sometimes rolling release of records. And I didn't address that at all in here. I'm not sure if it needs to be.
I don't think that needs to be related.
So I think. Any additional comments, Member Fisher?
No, I'm good.
So I think this is a good baseline for, like Victor said, clarification of what we've been doing, and I think your procedures in guiding departments and requirements of city departments, etc., are fairly good and fairly reasonable to assume such a thing as rule of reason. I would ask Victor what he thinks our next steps are with
I
this.
don't see a problem with just forwarding it with the suggestion that we question whether we should insert this into the complaint procedure or not,
Okay.
or if we should just keep it as a separate document to refer to people if they intend to invoke the rule of reason. We would send this to them saying you have to comply. These are the questions the task force will be asking.
Okay, cool. Do I need a?
No, let's just wait till the end and because the whole thing is going to be
Okay,
forwarded
the
up.
whole thing. Okay, cool. Let's move on to
The next one is reconsideration procedure. We've recently received quite a few requests for reconsideration, and our procedures for reconsideration is slightly outdated. It's on page 16, section D,
Yeah.
and I think we need to clean it up to make sure that we don't get invalid requests for reconsideration.
I don't think we should be reconsidering. Sorry, go on.
that could be an opinion that we shouldn't.
That was my opinion.
Suggest it to the task force to eliminate reconsiderations.
Okay. I didn't know that was a thing that we did. I think it just wastes.
We've been doing it we've had 3 in the last 3 months or so.
I know, and I don't like them, and I've fought against every one of them.
Yeah, so you can make the suggestion that we eliminate the procedure, but in our existing procedure, my suggestion is there's a section that says they have to offer proof that new information exists that wasn't present during the meeting.
Right.
So I think they should be required to provide that evidence with their request for reconsideration.
Right.
And provide the actual documents that you believe is new evidence.
That seems rational to me.
And then the section 2 is more of a procedural thing that we need to clean up, in that we're not sending these reconsideration, we're not putting them in the admin report because that slows us down. We're just sending it straight to the task force. And I would like to send reconsiderations to the committee instead of the full task force. Right now it says the task force or committee. I believe that language is okay, but
Would you like,
it's up to the chair and the full task force how they want to do this.
yeah, so from your perspective, would you like each individual committee to adjudicate?
It would be one of those things where any committee can review a request for reconsideration.
So they would review the request and then forward it to the full task force, or would they adjudicate?
Well, if they
the
deny it,
reconsideration?
that I believe that's something for you to determine.
Okay.
I believe if the request for that's a problem. A request for reconsideration going to committee, if they decide that it should not be reconsidered, can they kill it there, or does it need to go back to the full task force to approve that denial? And if that's the case, we might as well skip the committee step and just send it straight to the task force.
Right. And I'm not sure what Chair Wolf's feeling is about giving the committees authority to do that.
We can give them 2 options.
Yeah.
I believe option 1 is to eliminate it entirely. Option 2 is to, suggestion number 2 is to force the provision of proof and new documents or new information in writing.
Comments?
So just to state what I understand the procedure to be, if that's okay.
Go ahead.
So when an order of determination comes out, either party has 10 days to ask for reconsideration. And they can only ask for that reconsideration if information has become available that was not previously available that may, it doesn't actually, this is the part where it needs clarified. They just have to show whether there was new information that exists, and really that needs to be adjusted. But for the sake of working through the process, they have to show that there's new information available, and then the consideration can be heard by the task. So the petition for reconsideration can be heard by the task force or its committee. If it's granted, a hearing can be heard by the task force or its committee or a committee. So at this point, according to our policies now, a committee can adjudicate a reconsideration.
Yes.
So the first question, so the first thing I notice is that I don't think that the fact that new information exists is enough. It has to be new information that would affect the outcome that could reasonably change the committee's opinion. Like, it can't just be there was a new email we didn't get, but the email doesn't actually say anything. You don't get a new hearing just because an email, like a new document exists. But if a new document exists that shows that they inappropriately withheld information, then that's a different story, at least to me.
Yeah.
I believe at this point that's what we need to clarify is the new information that would change the outcome.
Yeah, because then how would you?
And I would like to get it in writing before the meeting, just because their declaration that there is new information, I think should be backed up with actual statement of what that new evidence is.
Yeah, I agree.
Yeah, I agree with that too.
I believe that's as far as we need to go with this one. I can rewrite some of the language to try to clean this up a little bit.
Excellent, yes.
And I believe the rest of the language, we could leave it at committee or task force, and it'll be up to the chair of the task force to determine where to send it.
Right. That sounds good.
I think next item, timeline for responding to.
Sorry.
Okay.
I'm just trying to remember the two cases that we had where we had reconsiderations and making sure that we're considering all of the reasons somebody might want a reconsideration. So the two that I recall.
We had one police department.
Right. The police department one, they asked for reconsideration because they were not present to make their argument. And then they came in saying that that there was confusion over the time that they were supposed to go, if I'm making correctly. And so
I believe that was part of it, but that wasn't the main concern.
but they weren't there to present the evidence that they
Yes.
wanted to present, and that was part of it. And I do feel like when there is a procedural mistake by the task force itself, that's on us, and that somebody should be able to ask for reconsideration if we made an error. So, for example, I mean, and like a clear, not like an error in that they disagree with our opinion, but rather if we said something was going to happen at 6 o'clock and we had the hearing at 4:30 instead, and they come and say, hey, your decision here was a procedural problem, they should have the opportunity to ask for a reconsideration.
That's something I can add in. Something about administrative errors, maybe can reconsider, or something of that nature. I can add that in as a suggestion. And that one,
Sorry.
and then the other one was Arts Commission. That was, they believe there's a new document.
There was this was the one with the
Passive versus
right policy meeting,
yeah,
sort of.
and we haven't heard that one yet, so we can't really talk about it.
Right. But I was just trying to understand the process. So that one was more the new information issue, though, and whether the new information is actually legitimate or not, we can discuss later. But that was
that one was regarding new information.
Right. So, I'm curious, Member Fisher, because you don't think we should do reconsideration at all. But if we make an error, is that different?
Yeah, I got two reasons why. One, if we make an error, then definitely. And two, if there is suddenly all this, new information that is clearly new, that, we haven't seen before, that's come out.
But my opinion is that with our procedure of hearing it before committee and then task force, they should have plenty of time to gather any information they need to gather.
I think that it's more, to me, it's like if I have a hearing, like if I put in a public records request to you and you're like, I don't have any responsive records, and I complain and I lose the case because you say there weren't any responsive records, but in the meantime I had filed a records request with a different agency that did show that there were correspondence with you about it, I could come back and say, listen, I actually have proof now that these things existed and you didn't hand them over, and that I may not have had those records, because of the timeline, how agencies respond to things.
I think that's a good simple example, but it's never that simple.
These are all, I mean, this, in essence, this is, kind of reminds me of college. This is a guideline.
Yes, I think adding a third section regarding administrative errors, and providing clarification of what new information, and that new information has to change the outcome, and that you have to provide it in writing. And I believe those are the two changes that we're suggesting at this time.
That sounds good.
I agree.
I'm just pushing us along as we're, running short.
Yeah, we're bumping up against the next group.
Timeline for responding to SOTF complaints. This is a suggestion brought forward by the Ethics Commission. At this time, we request that departments respond to a complaint submitted to the. When I send them the complaint, I ask them to respond within 5 business days. Ethics Commission doesn't believe that 5 days is enough time. They think more of a 10-day timeline to respond to our requests is appropriate. And
Is the timeline already in the bylaws?
it is in our, I think it's in the filing procedures.
Is that on
I'm looking for it right now.
page 21 maybe?
It's part of this. It's page 18, line 2. The SOTF staff, upon review of a complaint for completeness, shall refer the complaint to the respondent, who has 5 days to respond to the complaint. It might be in the bylaws also, but that's how it reads now. They have 5 days to respond. Ethics thinks that's not enough time.
Can we just change so 5 days to supply an initial response to the complaint?
Initial response, so they can follow up at a later time if they believe they have anything.
Member Moss, what would your definition of an initial response be?
I mean, I think we're looking.
Victor?
I mean, I think we're looking for acknowledgement that they received the complaint and that they intend to show up at the meeting, right?
Okay.
That's fine. I think that's a good compromise, that they give us what they have within 5 days, and they can give us additional responses at a later time. I think that would satisfy everyone's needs.
Member Fisher, where are you at with this one?
Well, you know how I felt about it in general, so I'll just go along with. When all else fails, I defer to Victor. I mean, really, if I have nothing,
It's not a
if
big-
it's not leaping out at me, I'm just
It's
going to
not a big deal
go
issue.
along with it.
And the other thing is, there really is no penalty if they don't comply with that 5-day.
Right.
If they don't submit anything within 5 days, I can't do anything about it. I'll pester them a little bit, but that's about it. Next on the list.
Sorry, can I ask you one more question about that?
Yes.
So the reason, was there a reason we set 5 days? Like, is it something
It was
that?
before my time.
Okay. Then never mind.
I believe they thought that was the reason, giving departments a week to respond.
Right.
But if there's a complex issue, it may not be able to respond within 5 days.
But it doesn't affect.
By adding the word initial, I think we can satisfy various needs.
Yeah, I think we just want to make sure it doesn't affect you getting packets together. And
Well, I would just make the packet without the response if it comes down to that.
okay.
The next on the list, this one is a little bit more complex. Process for complaints for parties who are unable to attend in person. Right now, I believe we leave it very vague in that accommodations can be made upon inquiry or something of that nature.
Well, we got legal issues on that one, too.
Yeah, we got 88 issues.
For some 88 company, I checked the LinkedIn.
Let me find the section regarding this.
Apparently, you do something for some 88.
Yeah, if only we had an expert,
Only we knew somebody that actually worked for an organization that.
Yeah, I think it was actually Member Moss that brought this one up.
Okay, I believe that's on page 14, top of the page, number 4. The respondent is, I'm just assuming that we're going to mention the complainant somewhere, but the respondent is required to attend the meeting. However, accommodations can be made due to special circumstances by consensus of the task force or its committee. That's just saying we want everyone to show up, but we can make accommodations as needed. We kept it general on purpose so that we can work with the person.
So, I think I had raised this before because it wasn't so much that it was the rules, it's just that was in the paperwork that people received where there wasn't like an option or there wasn't anything indicating that if they are unable to come due to accessibility issues, or they aren't able to come because they.
We can add something into my notice of hearing. Right now, I just write complainants are required to show up. I can add another line saying if there are problems, please contact me and we can try to work it out.
Right. I think that's a good way to go.
Yeah, I agree.
I can add it to the notice of hearing if that's something you want to consider, and we can work on some proposed language that'll be agreeable with everybody.
I mean, you could even add something in there about disability accommodations if that's a thing.
Yeah, I just.
Well, I mean, yeah, if somebody is, for lack of a better term, bedridden, house-ridden, what's it called? Housebound. That's the term. Housebound, homebound, or whatever, and can't get here. We have to accommodate them.
But and I just want to additionally like there's under the Sunshine Ordinance of the California Public Records Act, if you live in Portland, Maine, you have rights to file public records requests in San Francisco.
Yeah.
I think that's
We don't make any distinguishing.
Yeah. So we've had people from Oakland here. Yeah.
Right. But I mean, someone from Oakland traveling here is more reasonable than someone from Portland, Maine, traveling across the country to, spend.
Somebody from New York once.
Yeah. They're 3 minutes and they're.
We had two people from New York.
Yeah. They're 5 minutes and they're 3 minutes. I mean, that's a lot.
And then maybe we can add. Well, the general procedure, it's not written anywhere, is that you can have another person to represent you if you provide that authorization in writing, signed and in writing. That's our general policy that I go with.
I think maybe it's time we make that official in writing, maybe.
Authorization of party.
As an option.
Yeah.
And I believe we can add this language to the notice of hearing instead of to the procedures, just as it's, just so that they know that they can get accommodations if needed.
Yeah, I think that
I
works.
like that.
And I will work with the parties, members of the committee I'll draft something up and I'll send it to the task force to take a look at.
Okay.
Okay, next on the list is another big one, process for complaints and other issues to be initiated by members of the task force.
Was it you again?
This is partially Josh Wolf.
Yeah, I don't think the idea of
Oh, so remember when?
Yeah. Once.
So this came up twice.
if there's a concern by the task force that a department's not complying, can we initiate our own complaint?
Yeah, so that was the Complaints and Amendments Committee filed a public records request regarding the library matter with the libraries and the Friends of the Library supposed to have that document showing that the Friends of the Library, and so we filed a public records request by us, on behalf of the committee, but we weren't sure how to deal with it when it was not complied with, and we were.
And was it not complied with?
I'm trying. It's hard to recollect. I believe that there had been some questions about it, but
So just before you go down this path, just so I'm clear, this is if something happened here, and then a member of the task force or a subcommittee wanted to take it further. This isn't like what happened when Josh, for example, as a member of the public, had a complaint about another. That's something completely different.
that's
They're
something
just
different.
a regular person.
this is something different. This is.
That was also
Just checking.
Yeah, I think there's a
Just
couple. Yeah,
checking.
I think I got confused there, and I apologize. So I
So
think
it's
I
a
think-
regular person making a complaint is a regular person,
Yeah.
which is just
We have-
life,
we deal with that
versus
separate.
us coming in through. Yeah.
Right. I think there were two sort of issues that we needed to consider. One is if the committee itself files a public records request, how do we enforce it? And number two, if in the course of business of the task force, we recognize that there's a violation going on at a department, whether we can initiate a complaint ourselves. Like, say, we're going through a police department policy, and we know that we can tell based on their policy that they're in violation of the Sunshine Ordinance, whether we can do that, and then if that happens, who represents us before us, and how do we go about that? I don't know that we should deal with this one today. I feel like some feedback from DCA COLA would be useful.
Yeah, this one seems like what?
That's why it was pushed back down here.
Yeah.
Maybe we can just say we do it as a hearing
Yeah.
instead of having sort of like instead of opening a complaint, call them in for a hearing to say we have concerns that you are violating the sunshine in this manner, and have them come before and present a hearing to defend themselves, and not an official complaint, but just as a hearing to present their side of the story.
So part of me thinks about this. So if you recall, the Ethics Commission brought a complaint against the task force, and that actually did not involve anybody from the public filing a complaint against the task force with the Ethics Commission. It was the Ethics Commission had taken it upon themselves, I think, in regard to somebody else's complaint, to investigate us and to launch something. And the Ethics Commission does this all the time, right? Like they can audit people, they can launch an investigation. They have investigators who can do these things, right? We don't have a staff investigator who can just go like, doing that. We have unless Victor wants to do that.
We don't really do that.
No, we don't really do that.
That would be a new idea that we can test, but we would have to.
It's just who would actually. I mean, I can imagine circumstances where we recognize something and there is no complainant to bring the complaint, and so we would need to bring it ourselves. It's just I don't know how we'd have to come up with a new procedure for prosecuting that sort of thing. But I don't know if we can get to that today in the time left.
Yeah, I would suggest we get some feedback from DCA on this one.
So we can go ahead and continue this one to a future date, but of course, Mr. Cola would want some specific questions that you would. What do you want him to address and so forth? I'll be happy to forward any questions or.
What do we do?
How do we initiate a complaint?
I think
do
the
we want him
questions
to
are,
develop a process? Can we?
Yeah.
With the can we?
Yeah,
That's
can-
even possible.
Let's do it. Yeah, let's.
Yeah,
Let's-
can
And
the
if
task
there's
force?
any additional details to the can we, I would appreciate that.
I think the question is, can the task force initiate a complaint without receiving a complaint from the public?
Like, are we overstepping?
Yeah, can we initiate a complaint ourselves?
And if it's no, that's perfectly acceptable. We just want to know.
We can start with that.
Yeah. Well, it can, and then depending on the response to the can, then how.
Can and how.
Yeah.
Okay. Next on the list is a relatively complex issue.
Oh, lovely.
The vote requirement. This is.
I'm not touching that.
What does this mean, vote
It
requirement?
stays as it is.
At the last meeting, there was complaints that since we only had 6 members, they didn't feel it was fair to them to have to get a unanimous vote.
Don't go there.
Okay. Well,
Just so I understand. So the question here is, there's things that we could do, like one,
Nothing
like.
we can do.
Well, hold on. Let me.
hold on.
So
Your piece here.
okay. So
In the stack.
Vice Chair Highland had given everyone the opportunity to say whether they wanted their cases continued or not.
Yes.
Is that one of the options here, that if we do not, if we lose a certain number of members, that people in the audience, complainants have the option to.
It's not an official option, and that, to me, that's a problem.
Right.
In that we may not be a full 6, but what if we have 7, 8, or 9, they don't have 11, where's that cutoff?
Yeah, you can't gamble. You
Right.
can't-
It shouldn't
But I
be
just to articulate the issue, so I understand.
And I don't believe, my personal belief is it shouldn't be at the discretion of a member of the public to say how many members we have to have in order to provide a
The law
fair
says
hearing.
6. Quota is quota. Quorum.
Maybe the
And
solution
there
here
is
is
a
just
small difference in that we can take administrative issues, only require a quorum of the members present. That's for
Majority.
Majority of the members present. That's for things like continuing and so forth. They're purely procedural. But in terms of making findings on a complaint, it's a quorum of the entire body, which is 6 out of 11.
So perhaps to the discretion of the chair is where we should leave it.
It currently is at the
Can I go
discretion of the chair.
Sorry.
We don't really-
I've clarified
All
everything.
right, Member Fisher, give us your.
Thank you,
give
Chair
us your
Hinsey.
deal.
So,
But it was an issue brought up at the last meeting, so it's here.
Give us your sales
and I
pitch.
think we should answer it with, we find that it it is frustrating both for members of the task force and members of the public when there's only 6, but that's the way it was written. And back in 2009, a long time ago, there was this whole upheaval over that when a group of very well-minded, people decided to kind of overturn that. It did not go over well. I don't like it either. And it is kind of a gamble and a crapshoot, and it was unfortunate. I think it was last month. I had to leave early. Somebody else had to leave early. It happens. We're volunteers. We try to get as many people here as we can. I just don't think we can touch this. The only thing is I'm going back to my programming days, and I'm seeing this become an endless loop. So somebody comes in, they see 6, they go, wait a minute, I could lose if it's 5-1. I want to back out. Or they go through or we don't let them come back another time. Then they go through this, and then they want to do the thing that I disagreed with, the reconsideration procedures, because it's like blackjack. Oh, I'm going to go when there's 9 people. I got a better chance. So, it is a difficult situation, but I don't think there's much we can do about it. I think we have to stick with the rules, as they say, until we could, I don't know, what would it take, like a ballot measure or something to overturn that?
I find Member Fisher's argument persuasive.
Yeah. Carry on.
And I don't know if you want to, right now, there's no guidelines on when we will allow continuance or not. It's really at discretion of the
That's
chair.
the discretion of the chair. I think Bruce can make that decision.
It's just, however,
Full
I
faith in-
caution you about having different decisions on different days, where one day you allow it and one day you don't, at the discretion of the chair.
The discretion of the chair would have to be very discreet. Discretion-y. Consistent. That's up to Fiona.
Make note that he's here or something.
Fiona.
Member Wolf has walked in, and he would like to say something, so I will give him the floor.
Yes, sorry.
Use mine.
I got it. Okay.
Thank you. Hello. So I'm just here for the next meeting, but so I'm not a voting member of this committee, but I wanted to add a little more breadth to this particular subject. Part of the situation is also we've had now 2 vacancies that have been outstanding for some time. So I've been reaching out to both the Society of Professional Journalists and New American Media. They are desperately trying to find nominees to fill these seats. We hopefully we'll have an answer from them in the next couple of weeks, 2 to 4 weeks, hopefully, and that will help solve that problem. I do understand and feel for the public when they see only 6 people sitting here. We call that tyranny of the minority. It could just be one person voting no every time and nothing passes. So, but to answer Member Fisher's question, yes, it will take a ballot initiative. We know that there's a number of former chairs that are working on amendments that will definitely help adjust this in that. But it still is not quite clear whether we are required to follow what's in the charter or not. So the best way to deal with it is to put it back before the voters and let the voters decide. Thank you. Chair Hinton.
Next item.
The next one is most likely going to need to be continued, is developing a process for reviewing redacted documents. In the last couple of months, we've had many hearings where a department would state that the document is protected for some reason and could not be provided. However, the task force could not review the documents to determine if the reason was valid or not. And suggestions were made regarding having an outside party who, such as a court or a judge, review the documents and make that determination for us, or something of that nature. But that is, I would believe, a pretty complex procedure to set up. And
Yeah.
What have we done in the past? I mean, we've been doing this since 1999. This should not be new.
it's a matter of, do you believe the department, and how much proof does the department need to?
But I'll answer my own question, because this has happened in the past, and we've come back and said, no, you've got to give us that information. And then we give a violation, and then it goes to some committee, and if it's really bad, it goes to ethics, and it's a violation. I mean, that's what we do.
Well, we just can't review their justification if we don't know we believe that their justification is correct or not.
I mean,
And we
I'm
can't
going
make
with
that determination.
our opinion. If our opinion is, and again, this is just opinion because we can't see the document, if our opinion is that we're not buying it, or and I'm being very careful with my wording here, if our opinion is that maybe something is being held back and we're not, doesn't seem quite trustworthy, then we file a violation and we move on from there.
Okay.
And then maybe if there's a violation, then you go a deeper level, and then, oh, suddenly we do have to give this information.
I think it would be a case-by-case scenario.
Yeah.
It's
But-
really hard to make a,
But on the other hand, I'm a huge privacy advocate, so a lot of times, there are things I see there. We had a case a few years ago where somebody wanted, it was home address information and all this other stuff, and I was like, whoa, no. So, sometimes redaction is your friend, sometimes it's your foe. A little off topic, sorry.
All right, so this one I don't think we can come to it.
I believe Chair Wolf is, or Member Wolf in this context.
Guest Wolf.
Guest Wolf.
Yes, Wolf, thank you.
How come I never get to talk when I'm a guest on other committees?
You can come in and
I was told I couldn't. I was told I couldn't.
you can. Well, I'm telling you, you can.
I'll start coming.
Sure. So I think what might be good is to see if we could maybe contact somebody over across the street at 450 McAllister and see if they could maybe assign a judge when we make a request to, or even a retired judge, that they would give authority to take a look at the information and then just make a determination as to whether they feel that it falls within the citation that the respondent is making that authorizes the redaction.
That might be worth. It would be at least worth reaching out to them to see if that could be done.
Mm-hmm.
So
Isn't that a budgetary issue, though? I mean,
we can
we
look
can't even
into
get
it.
the damn
Nothing
cameras on.
prevents us from looking into it.
Okay.
Yeah.
Well, just keep it simple. We have a lawyer. He's a lawyer. He's bound by the laws of the California Bar Association. Can't he review it?
And
Or
then there's
she.
a matter of whether or not the departments agree who is
Authorized to see it.
authorized to see it.
A court would be expressly allowed because it's in camera, it's within their jurisdiction and their authority to do it, not necessarily an attorney.
yeah,
We can look into the matter further,
into
and
it.
I can
Yeah.
report back.
Yeah.
look into it and see.
We have to give
Yeah.
him in 9 minutes. All right.
We're at the end of our list, unless the committee has any other issues not listed.
All right. Do we have public comment on this item?
Should I make a motion first, or
Okay.
move to
Move it
approve?
up to them.
There's nothing. Are
Move
we
it up to
approving
the-
it?
Do I
to
move to approve the
Suggestions?
the recommendations we made today and to send it to the full task force for discussion?
Is there a second?
I'll second that.
All right. Can you call the roll?
Nope, public comment.
Public comment first.
We have public.
Is there any public comment on the discussions regarding the bylaws and complaint procedures?
It's kind of hoping that Michael Jackson got.
My name is Francisco da Costa, and I was listening intently to the San Francisco Ethics Commission yesterday. More or less the same type of dialogue y'all are having over here. So, as you said, in 1999, we formed the San Francisco Sunshine Task Force. And just listening to y'all, I see that we miss a lot of the former members who were astute and did a lot for the Sunshine Task Force. And so things slip in between the cracks, and we see that now even the supervisors will target the Sunshine Task Force when it comes to appointing somebody for a seat that has to be filled. And I see y'all debating on some pretty critical issues of process. But what I don't see is the vision for the future. We are in the digital world. We are in 2017. And we have other ways of gathering information and speeding up adjudication. So I challenge y'all. This is San Francisco. San Francisco. We have commissions. Our ethics commission doesn't even bother. I mean, they don't want the public to come and criticize them. It's like you just have to listen to them. No, San Franciscans will criticize because they have their First Amendment rights, but also most San Franciscans are astute. You see me at City Hall giving them a hard time because you have to rock the boat. If you don't rock the boat, we are not going to go to a better place. Now, I represent the first people, the Muwakma Ohlone. I have added responsibility. I tell them oftentimes that they stole this land, each and every square inch. And what have we done as far as quality of life issues are concerned, human rights are concerned, making us better human beings? We cannot say we are good human beings when we act like that guy who's in the White House. We cannot say we are better human beings when we don't step up and defend the poor and those children and others that need our help. So those are my comments with a little deliberation that I heard. Thank you very much.
Thank you.
Any additional public comment? There being no further public comment at this time, on the motion, Member Moss.
Aye.
Moss, aye. Member Fisher.
Aye.
Fisher, aye. Chair Hensy.
Aye.
Hensy, aye. The motion passes. Next on the agenda is item 5, announcements, comments, questions, and future agenda items by members of the Rules Committee.
Got it.
I mean, the only comment I would make is that our first public comment speaker is yet further evidence why we should have cameras in this committee. For member guest Wolf, who's not here, we had a Michael Jackson impersonator testify earlier, and it would have been great to have that on camera.
During public comment.
Yeah.
I wanted to selfie him, but it just didn't seem appropriate. I was trying to keep professional.
That's all I have.
No, there being no further business, item number 6, adjournment.
That's you.
Adjournment, yep. Motion to adjourn?
Second.
Yep.
Sure.
All right.
The meeting is adjourned.
I mean, he had the body and the